Good evening, everyone, and welcome to the Rent Stabilization Commission meeting of the City of West Hollywood tonight on Thursday, February 11th, 2021. Please follow me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein.
Here.
Commissioner Charity.
Here.
Commissioner Copeland.
Here.
Commissioner Kirby's.
Here.
Commissioner Maggio.
Here.
Vice Chair O'Keefe.
Here.
Chair Topshin.
Here. We have a quorum. Thank you. Approval of agenda is our next item. Commissioners, please note that we will have one appeal tonight. The first appeal, case number D-4503CD, has been rescheduled for March 11th. Is anyone would like to make a motion to approve the agenda items before us tonight?
So moved.
All right, we have a, who was it?
Second.
Okay, we have a motion to approve the agenda and we have a second. Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein.
Aye.
Commissioner Charity.
Yes.
Commissioner Copeland.
Aye.
Commissioner Kirby's.
Aye.
Commissioner Maggio.
Aye.
Vice Chair O'Keefe.
Aye.
Chair Topshin.
Aye. The agenda is approved. Next is approval of minutes. Commissioners, has everyone had a chance to review the minutes from our last meeting on January 28th?
I sent a minor cleanup correction to our secretary. It was the language on a question that I had for staff about the program where the state may offer landlords 80% of the rent if they waived the remaining 20%. And the point I made was that if a landlord could refuse that assistance, and the cleanup language is that it could result in the landlord filing an eviction and that legal services are available to our residents in such cases.
Thank you. Thank you, Commissioner. Other changes, amendments? Do we have a motion to approve as amended?
I'll move to approve as amended.
Second.
Okay. Okay, we have a motion and a second. Mr. Secretary, may we have a roll call, please?
Commissioner Bergstein.
Aye.
Commissioner Charity.
Aye.
Commissioner Copeland.
Aye.
Commissioner Maggio. I'm sorry, Commissioner Kirby's.
Aye.
Commissioner Maggio.
Aye.
Vice Chair O'Keefe.
Aye.
Chair Topshin.
Aye. Motions, minutes are approved. Thank you. Next is public comments. Mr. Secretary, do we have any speakers at this time?
Not at this time.
All right. Since we don't have any speakers, we're going to move on to the next item, which is the manager's report. And here we have Acting Rent Stabilization Housing Manager, Mr. Jonathan Paula.
Thank you, Chair. Good evening, Vice
Hello.
Chair as well, and Commissioners. Jonathan Hollow, Acting Manager, Stabilization and Housing Division. On our look ahead, we've got, for tonight, we've got one appeal, and we're concluding the item of the letter regarding broken elevators. Since no substantive items were presented for the next meeting, we're going to be taking that off calendar. As of March 11th, we've got the item that was continued from this evening, 4503CD. We'll also be bringing forward an item with a draft amendment to the temporary relocation ordinance, integrating some of the suggestions that were made in the letter that's being presented tonight. The 25th, we will be discussing valuation guidelines. Staff is currently doing research into that. Currently on the 8th, we don't have anything yet, but I do anticipate that we might get some appeals in here between now and then, certainly within the next few weeks. On the 22nd, we'll be discussing an adjustment to the security deposit interest formula and seeing if there's a need to amend the ordinance in that respect. And staff is also currently doing research on that issue. We might have some items coming up regarding subtenancies based on what I discussed last week, doing more research into that to see if a regulation or an amendment to the ordinance would be appropriate. And also with respect to establishing move-in dates for hearings. That's all I've got, but before I conclude, I'd like to introduce our Director of Human Services and Rent Stabilization, Christoph Schroeder, joined us tonight. So Christoph.
Good evening. Thank you, John. Chair, Vice Chair, Commissioners, good evening again. I just wanted to check in and introduce myself to those of you who I don't know and reintroduce myself to those of you I do. I've worked with the city for 24 years. In my early years, I served as legal counsel to this very commission and enjoyed it greatly. I then became manager of legal services and legislative affairs in 2000. And in 2015, I was appointed director of administrative services, where I oversaw legal services, city clerk, and human resources. And last month, I was appointed director of this department, and I'm really excited at the opportunity to serve in this capacity. And I look forward to working with all of you. So thank you for your time, and thank you for having me.
Thank you, Director Schroeder. It's a pleasure to see you again back to the commission. Congratulations with your new appointment, and good luck on that position. And clearly, with your background and your experience, we couldn't probably have the better director.
Why, thank you.
Department.
Thank you, Chair.
Congratulations. So hope to
Thank
see
you
you
very
again
much.
soon. Yeah, and
Most definitely.
right, we'll look forward to working with you too.
Thank you. Thank you all.
Thank you, Christoph. That concludes my report.
Okay, thank you, Mr. Manager. Commissioners, are any questions to the manager? Not at this time. All right. Thank you, Manager Holub. So with that, I'll move to the commission comments. Commissioners, anything at this time? Commissioner Kirby, please.
Just wanted to congratulate Christoph on the position and look forward to working with him in this new role. Worked with him for many years, and he'll be great.
Thank you. Other commissioners? All right. If no more comments, we'll move on to the next item on the agenda tonight is the appeal section. And we have, as I said, we have one appeal scheduled tonight, and that is application D-4554, pertains to the property address 1209 North Formosa Avenue, unit number 4. This appeal has been filed by the property owner. Commissioners, as a reminder, please make sure your video is on and you are visible at all times during the appeal. All right, Mr. Secretary, I would like to check if we have both parties present and if the connection is set properly so them to speak.
We do. I'll admit them now.
All right, thank you. Thank you, Mr. Secretary. Before we begin, I would like to take a moment and explain the appeal process for the parties. First, the commission will hear the staff report presented by the department's legal counsel, Mr. John Natalizio. Commissioners may direct their questions to the legal counsel. After that, each party will have 5 minutes to address the commission and present their case. The appellant, in this case, the property owner, will go first and will be able to divide the time between the presentation and the rebuttal portion. And the respondent, the tenant in this case, will go next and will take a total of 5 minutes entirely to address the commission and present the case. Please keep in mind that tonight's appeal is not a second hearing. The commission will only review the grounds for which the appellant believes the hearing examiner's decision is incorrect. Therefore, no new issues may be considered by this commission, nor may new evidence be admitted unless it is demonstrated why the evidence could not, within due diligence, have been presented at the hearing. Please keep your comments to the issues discussed at the hearing. The legal counsel or I may interrupt you at any moment if you go off topic to introduce any new evidence or information. Once the oral argument portion of the appeal is closed, the commissioners will begin deliberation. All right, with that, Mr. Natalizio, please present your report.
Good evening, Chair, Vice Chair, Commissioners. My name is John Natalizio, and I am the legal counsel for the Rent Stabilization Commission for the City of West Hollywood. This appeal was filed by Stanley Davis, who is the landlord for a property located at 1209 North Formosa Avenue. This hearing is involving Unit 4 of that property. David Arnn, who is the tenant in Unit 4, originally applied for a determination of the maximum allowable rent and whether the landlord had retained rent in excess of the MAR. The hearing examiner determined that the MAR was $575, which was the rent charged at the initiation of the tenancy. At the time of the hearing, the rent was $896.19. The hearing examiner noted that there was no evidence that the unit had been re-registered after Mr. Arnn filled the vacancy. Therefore, the hearing examiner found that the landlord had unlawfully imposed the annual general adjustment since the beginning of Mr. Arnn's tenancy. The hearing examiner calculated the excess rent during the 38-month period between September 2017 and October 2020 and found that the landlord had retained excess rent in the amount of $10,115. Mr. Davis's appeal challenges the hearing examiner's decision regarding the determination of the MAR and the excess rent calculation, claiming it was clearly in error. Specifically, the appeal is based upon an apparent 2014 lease agreement that was attached to the appeal application. Mr. Davis claims it was executed by himself, Mr. Arnn, and a new additional roommate. The new lease increased the rent to $825. Mr. Davis questions why this new lease agreement was not considered at the hearing. Notably, the appeal application does not challenge the finding that the unit was never re-registered. Staff has reviewed the hearing examiner's decision and the appeal application and recommends affirming the hearing examiner's decision and adopting resolution number 21-591. Staff agrees with the hearing examiner's finding that Mr. Davis was required to re-register the unit after Mr. Arnn filled the vacancy and that Mr. Davis failed to do so. Staff finds that the hearing examiner properly determined that when a landlord fails to re-register a unit following a vacancy, as required by the RSO, the landlord is ineligible to apply any AGA while the unit remains out of compliance with the RSO. Staff also finds that the 2014 lease attached to the appeal application is new evidence that was not presented to the hearing examiner with due diligence and should not be considered by this commission. Staff finds that even if the commission did consider that 2014 lease, the rent increase was beyond what is permitted in the RSO and is therefore unlawful and void. Therefore, staff finds that the hearing examiner correctly determined the MAR to be $575 and the excess rent collected by the landlord to be $10,115. You as the commission have the power to affirm, reverse, modify, or remand the appeal determination of the hearing examiner as you deem fit. In this specific instance, your review of the hearing examiner's decision is to determine whether the landlord lawfully implemented rent adjustments and whether the hearing examiner correctly determined the MAR to be $575 and the excess rent collected by the landlord to be $10,115. Thank you.
Thank you, Mr. Natalizio. Commissioners, do you have any questions? Commissioner Kirpis, please.
Yeah,
Next is
one
Commissioner
question.
Bergstein.
I just have one question about, so in a overpayment case, the tenant is able to request 3 years worth of overpayments, right? Or the previous 3 years up to. I noticed that there's 38 months rather than 36. Is that the 2 months between the decision and the appeal, or what is that 2 months? It's almost actually referenced at one point where it mentions the 2 months, but I wasn't sure. On
That's
page,
I believe
96.
I believe it's 3 years back from the application date. I think that's what the 38 months is referencing.
And then the tenant, when they have the hearing, the tenant continues to pay whatever is being asked. And then that, is that where we're getting the extra 2 months? It says that in the 2 months thereafter, I'm not sure, September 2017, August 2020. Was August 2020 the hearing date?
Let me see. The hearing date was, yes, in August 2020.
Okay.
Yes, August 17th. Excuse me. No, the hearing was conducted on October 12th, 2020.
But we're allowed to, if we choose, if we find in favor of the tenant, we would be able to include those extra 2 months. I guess that's my real question.
So you would be able to determine from up until the date of the hearing. And then my understanding is that if the tenant continued to pay excess rent after that hearing date, the landlord is required to return all excess rent. And so that would be something that if the commission determined that the MAR is $575, then the landlord could talk with support staff about what is the total amount that they ultimately owe. But the commission tonight can only decide up until the date of the hearing.
Okay, thank you.
Thank you, Commissioner. Commissioner Bergstein?
I have two questions. Just I'm curious, on page 86 of our packet is a document I haven't seen before. It's a city MAR document, and that I'm just curious as to we know what that is. It may not have any relevance, but I was just curious when I saw that page.
Yeah, so that document was submitted with the appeal application. I have reached out to staff to determine what that document is. Staff was not able to determine specifically what the document is, but they were able to confirm that it was not a re-registration form. And then as to what it is, staff is not certain, but is inquiring internally.
Okay. And then second, if this is not relevant and you don't want to answer, that's totally appropriate. But it is my understanding that when an existing tenant adds a roommate, adds a new roommate, adds a spouse, landlord cannot require a new lease. That the most that a landlord might be able to do is require an application and a background check for that new roommate or spouse. Is that correct?
So I will agree with you in terms of this deliberation. That's not relevant, but but to answer your question, that won't be considered in this deliberation. Yes, a landlord, there are certain requirements in an RSO where a landlord has to require a tenant be included into the unit without any sort of new lease being signed. An example could be a spouse.
Thank you.
Thank you. Commissioners, Vice Chair O'Keefe, please.
Yes, I believe this was implicit in what you said, but just for the record. So we cannot consider the document on page 86 because it is new evidence that was not presented before the hearing, unless we were to find that there's an exception because it could not have been presented with due diligence, correct?
That is correct.
And the same is true, as I think it says in your staff report, for the lease itself. It was not presented at the hearing, so we cannot consider it at all unless we were to find an exception, correct?
That is correct.
Thank you.
Thank you. Other commissioners? I have a question, and Mrs. Natalizia, just feel free to let me know if it's irrelevant to the deliberation. As you pointed out, and the examiners obviously determined the rent adjustments were not lawfully imposed. We know the reason why, but my question is, I wonder if the rent increase notices were issued, written notices were properly issued and served prior to the increases, because we see the payments, the actual proof of payments, how the amounts changed. But I wonder if the examiner looked into the actual written notification requirement.
And you're talking about for the AGAs?
Yeah.
So So yes, I will say that that matter was not appealed, so it's not relevant to this deliberation. However, the hearing examiner does not make any sort of finding that the tenant argued that he was not provided notice of those rent increases. But for purposes of this appeal, notices of the AGA are not relevant.
Okay, thank you. All right, I don't have any questions. Commissioners, if you don't have any more questions, I will open the oral argument portion of the appeal tonight, and I will invite the property owner, who is the appellant in this case. It's Mr. Stanley Davis. Sir, before we begin, please, first you will have to state your name and the city of residence for the record, and please indicate if you would like to divide your 5 minutes between the presentation and the rebuttal portion, or if you want to take all 5 minutes at once. Just let me know what you want to do before we proceed. Can you unmute yourself? We can't hear you.
Yes.
Perfect.
Is that better?
Yes.
My
Just
name is Stanley Davis, and I do choose to split the 5 minutes.
Perfect. So how would you like to split it? How many minutes you want to take now?
2.5 and 2.5.
Perfect. Mr. Secretary, noted, please. All right, sir, you may begin.
Okay, I have everything ready to go. I believe the hearing examiner's decision is incorrect because with due diligence, I couldn't locate the original lease, which includes the landlord disclosure forms, which shows the maximum allowable rent, which by the way, was not required to be sent to the Rent Control Board at the time in 1997. Property owner and tenant only were noticed, as it says right on the form. And that is the form that was given to me to fill out by the city. This file goes back 24 years to 1997. I had relocated my office a number of years ago, and only after the original hearing was I able to locate the file with extreme due diligence. The entire case seems to hang on the presence of the MAR file, which was included with the lease to David on February 24th, 1997, almost 24 years ago. The tenancy was re-registered as required by the city at the time with 30 days of lease signing, and it happened actually the same day. And that was the form that was given to me for re-registration by the Rent Control Board. That's it.
Thank you. That's it. That concludes your statement at this time.
That's my statement.
All right. Thank you, sir. Mr. Secretary, can you let us know how many minutes Mr. Davis has?
Yes, he has 3 minutes and 26 seconds remaining.
Wonderful. Thank you. Commissioners, any questions to Mr. Davis? I see Commissioner Charity and then Vice Chair O'Keefe. No, I'm sorry. Then Vice Chair, please.
Mr. Davis,
Yes.
you did not appear before the hearing, correct? You weren't there?
Correct, yes.
Okay, thank you, that's it.
Thank you. Other questions?
Yes.
Commissioner Kerpis?
So to follow up on that, you're not arguing any reason why you weren't there at the hearing tonight?
Well, I didn't have the lease or the MAR form, and I felt
Okay.
I didn't have any case at the time. I had relocated my office, and we are going back 24 years.
Thank you. And then the other question I have is just so I understand your argument. Your argument is that the tenant moved in 1997, not 1999, and that you did register in 1997.
Absolutely, and you do have a
I
copy
just
of
want to make sure I
the
understand the
actual
argument.
lease.
Great, thank you.
Thank you. Any more questions? Seeing none. All right, sir. Vice Chair? Yes, sure.
I'm sorry, one more.
That's okay.
Mr. Davis, you also did not request a continuance to be allotted more time to try to find documents or otherwise request a continuance, correct? Like a delay in the initial hearing?
Correct.
Okay, thank you, sir.
Thank you. At this time, I would like to bring up the tenant, the respondent in this case, Mr. David Arndt. I'm sorry if I ruined it, if I mispronounced your last name. But sir, again, you will state your name and the city of residence for the record, and you will have 5 minutes, a total of 5 minutes to speak and to address the commission. You may begin now, sir.
Okay, good. You pronounced it correctly, Arndt.
Okay, perfect. Thank you.
Thank you. Good evening, everyone. This all started this summer. It was brought to my attention by City Hall that I was never registered. They suggested that I follow through with all the hearings and that kind of stuff. So that being said, Mr. Davis is absolutely correct. He did bring a lease. I don't have, I guess maybe the 2014, I'm not sure. And I didn't realize that I did move in 1997. I thought all this time that I had moved in 1999. So 24 years goes really fast, I guess. As far as registration, when I moved in, I have no idea about that. As far as re-registering, I was told by the hearing examiner the first time that he asked me if Mr. Davis brought around paperwork for me to sign to be re-registered, and I said no. I have not seen Mr. Davis 2 or 3 weeks prior to the hearing date. And that's all I really have to say. It's up to you guys.
Okay, that concludes your statement?
Yes.
All right, thank you.
Any questions?
Yeah, commissioners, let me ask the commissioners if they have any questions to you, sir. Commissioners? Commissioner Kerpis.
Yes, thank you for your honesty about the recollection or change in recollection of when you moved in. I appreciate
Sure.
that. Have you had a chance to see the document in our packet, which is, I don't know if you can see this at all, but it says City of West Hollywood at the top. It's page 86 in our, it kind of looks like a certificate.
I don't have that. 80 pages?
Yeah.
No, I have nothing like that.
Do you have a copy of what the city produced for our agenda tonight?
Notice of appeal?
My question, I guess, really is this document
Procedural background?
the document right here. I don't know if you can see this at all, but it's the certificate.
No, it disappeared.
No, it disappeared. Let me try.
Sorry. Yeah, thank you.
Document.
Sorry?
Just, do you recall this signing this document? What, this is the document the commissioner is asking about.
Kind of hard to see. Maybe we can just.
Yeah. Oh, I don't know how to, yeah, does the secretary, can he bring it up?
This is
Sure, I can share my
It's
screen.
page 86 of our packet. It's the,
Sure, I can bring that up now.
Oh.
Mr. Arndt, is this document right here? I know it's hard to see.
I have it.
Okay, do you recall, is that your handwriting in the tenant name and site? I mean, do you remember filling this out at any point?
In 1997? No, I don't remember, but that is my name.
Do you believe that
And my signature.
your signature, the signature you put on it? Just want to make sure
Yeah.
that does, okay.
Yes,
Thank
it
you.
is.
Thank you. I really appreciate your willingness to answer these questions. That's all, Chair.
Thank you. Other commissioners? All right. I don't see any more questions to you, sir. And with that, I will invite back Mr. Davis. You will have the remaining 3 minutes and I believe 20 seconds, you said, Mr. Secretary?
That's correct, 3:26.
Could you hear me now?
Yeah, we can hear you now. You can
Well,
take the remaining time.
My whole case is based on this Department of Rent Stabilization landlord disclosure form that, I've owned that building since before West Hollywood became a city. And they started 1984, which they became a city. I believe that was the year. And I've always filled all the requirements, whatever they wanted me to do. And when I rented that apartment to David, this is the form they told me to fill out. And it says right on the form, the original and the copy go to the tenant and the property owner. It does not go to the city. They did not require that. I fulfilled my obligation totally. And that's pretty much all I could say.
That concludes your statement?
Yes.
Your testimony? Okay, thank you. All right, commissioners, any questions to Mr. Davis?
I do, but I have a question for legal counsel first.
All right, so let me first, if you don't have questions.
No, I do, but I want to make sure.
Well, I need to close the oral argument portion of the appeal before we can begin the questioning, sending questions to legal counsel. So at this point, if you don't have any questions to Mr. Davis,
then I have a question for Mr. Davis.
Yes, please.
Mr. Davis, what's the reason for in 1997 the tenant paid $705 and then later on he dropped his rent to $585 or $565?
He did not pay $705. That was the maximum I was allowed to get in rent because in the 80s, I had done a lot of remodeling work, and in those days you were able to get a higher cap. But when I rented to him, the going rent was $575. So that's where that figure came from.
Thank you.
Thank you. Other commissioners? No questions. All right. So thank you, sir. Thank you, gentlemen, for your presentation. And I will close the oral argument portion of the appeal, and the commissioners may begin discussing this case, may begin your deliberation. And if you have any questions first to the legal counsel, I know Commissioner Kirkus, do you want to ask a question?
Yeah, my question for legal counsel is, although we have to base our determination on what occurred at the hearing, this is a de novo hearing, and one of the witnesses recanted on his testimony in the previous hearing. Are we allowed to use that information to adjust the spectrum of what we're looking at, or the broaden what we're looking at, or would that justify, that's my first question. And then the second question is, would that alone justify us remanding it back to the hearing examiner, given the new information?
Correct me, I guess, if I'm misunderstanding your question. But in terms of what's at issue in the appeal, it's really going to be whether or not the MAR and excess rent were determined correctly. I think in terms of whatever this form is on page 86 of the packet, it doesn't seem to me to necessarily change anything. Again, all I have is staff's confirmation that the document that was provided in that appeal application doesn't match any sort of re-registration form that the city has. And the city has required re-registration since 1996. So if the question about recanting is relating to whether he moved in 1999 or 1997, I don't think that has any bearing ultimately on the matter before the commission, because no matter what, the initial rent is going to be $575, and the re-registration requirements didn't change. Perhaps if the re-registration requirements had changed, that would be a factor, but here it's not. So at least from staff's perspective, whether it's 97 or 99, it doesn't affect this appeal. And then as to your, I believe your other question is are these circumstances enough to warrant considering this, I guess, outside evidence? I can't determine that because that's a commission decision about whether or not that exception is met. Again, as Commissioner or Vice Chair O'Keefe pointed out, as well as Mr. Davis said, he didn't attend the hearing. He had he said he couldn't find the lease or these documents, but he didn't request a continuance. So it's ultimately going to be up to the commission if they think that Mr. Davis has conducted due diligence, and if the commission does decide that, then they could consider that. But as I stated in my opening comments and in the staff report, staff, after hearing Mr. Davis, staff doesn't change its recommendation that the outside evidence provided in the appeal application cannot be considered.
Then can I ask, is it appropriate for me to ask detailed information? I don't want you to answer. I just want to know if it's appropriate for me to ask you. Am I able to ask you detailed information about who you spoke with at City Hall and what led you to the conclusion that this is not a document from the city?
Yeah, I mean, I don't think that's anything like attorney-client. I reached out to John Hollub, and he reached out to staff within the city, and that was what was relayed to me.
Thank you.
Thank you. Vice Chair?
Yeah, I have a question for our council as well. On the question of if there was due diligence or not, if members of the commission wanted to consider new evidence, which would only be allowed if we found that with due diligence it couldn't have been considered, do we need a separate vote on that as a whole, as a commission, to decide if it can be considered?
That's an interesting procedural question. Well, I mean, I think what the commission would have to do is deliberate about whether or not each commissioner would consider this new evidence. And ultimately, at the end, the commission would have to vote. And I would imagine that those who are considering the evidence are going to probably vote one way, and those who are not considering the evidence are going to vote another. I guess there could be a situation where people are considering the outside evidence and do vote, with people who also haven't. But I don't think there has to be a separate vote about who's going to consider the evidence or who's not, just as long as it's a part of the deliberation.
Okay. Thank you. Commissioners?
Start.
Again, I wanted to, Mr. Natalizio, so this document on page 86, that is called landlord declaration form. So that is not, this is not the re-registration form that existed in 1997. That's what you're saying, right?
That's my understanding, correct.
So this, whatever the document is, this is definitely not the re-registration form that the owners were required to sign at the time in 1997.
Correct, that's my understanding, yes.
All right, thank you. Other commissioners, questions? All right, so now Commissioner Copeland, please. Yeah.
Hi, I just wanted to expand a little bit on the on this particular form, just in case it's relevant. It does say landlord disclosure form. It doesn't say anything about registration or re-registration, and the content of this form, is that also not what would have been used for re-registration at that time? Is that our understanding of it? Or is that an okay question to ask?
I will say that
the title of the form is definitely different, but as far as content, that's also not what would have been used at that time, is what we're understanding.
Correct. That's the staff understanding. Yes.
Okay, thank you. That's
Thank
all.
you, Commissioner.
Thank you.
All right. All right, with that, I think we shall begin our deliberation, and would like to jump in, commissioners. Then Commissioner Bergstein, maybe you can begin, and I will go in alphabetical order.
Sure. So first, just a general comment, not really relevant to the hearing, but reviewing the lease that we are not considering. There's some general deficiencies. I always warn all landlords that there's no allowable increase on a lease for when a second tenant moves in. And also be very cautious about naming a dollar amount for a returned check charge. Per our ordinance, it's whatever the bank charges. So those are just some general comments, not really relevant to my decision. The form that we've been discussing on page 86, as Commissioner Copeland said, does not have the information that would normally be disclosed on a re-registration upon new tenancy. The re-registration shows, not only the names and the dates and the dollar amount, but all the housing services that are provided, draperies, flooring, parking, and that's not included. So I'm not saying it is impossible, but it is improbable to my way of thinking that both the city and the landlord lost a re-registration form. I would understand if one party had it or the city had it, but for both sides not to be able to locate a copy of re-registration, I don't believe that one was filled out. We have no evidence that one was filled out at the time of tenancy, and there was a standard form. It was a triplicate handwritten form, if I remember. As commissioners, we have seen those documents dating back into the late 1990s, so those forms were available. So for me, this is not a complicated issue, that the landlord never filed a re-registration form upon new tenancy, so no AGAs can be taken as such. That subsequent lease to raise the rent, because addition of a tenant is also completely outside the scope of the commission, that would not be allowable. So I will be voting in favor of staff's recommendation.
Thank you, Commissioner. Commissioner Charity, please.
Yeah, I come to the same conclusion as Commissioner Bergstein, just from a different route. I see the only date that was relevant was 1996, after which a re-registration form was required. And in this case, we simply don't have that evidence at the hearing. We are not supposed to take into account new evidence that wasn't present at the hearing. As Commissioner O'Keefe pointed out, there is a mechanism for a continuance request. We actually had a continuance request tonight for another appeal. And also, we aren't the last stop. The system does work. If the parties wanted to appeal to the next level above us, the Superior Court, then they could. But as it stands, this landlord simply hasn't proven at the hearing that they were eligible for the AGA increases. And I simply have to go on what was present at the hearing, and I can't speculate what I don't know, which is not knowing about this form, not knowing, the contents that should be in the form for a successful re-registration form. We have the word from our city attorney that this form was not the form that was recognizable to staff. So I am in favor of supporting the staff recommendation for those reasons.
Thank you, Commissioner. Commissioner Copeland?
Yes, I also believe that the hearing examiner both interpreted and applied the law properly in the hearing. Outside of any issues that have been brought up today, they were not brought up in the original hearing. So I don't really think that has any bearing on my decision. But as of now, I would support staff's recommendation to affirm the hearing examiner's decision. That's all.
Thank you.
Yeah.
Thank you. Commissioner Kerpes?
Yeah, I agree that the hearing examiner made no error in this, in his findings. However, we had one of the parties of the cases this evening voluntarily, unnecessarily provided information that contradicted his singular statements that were made to the hearing examiner at the time. That alone, just changing the dates doesn't necessarily mean anything, but it also means that, combined with the fact that we are holding a de novo hearing tonight, not just based on whether the facts are right or wrong, but actually about how to apply the law. I think that we do have jurisdiction or the ability to look at this more closely. But instead of doing that, I think that I would recommend that we refer it back to the hearing examiner so that the hearing examiner there's no harm in sending it back to the hearing examiner. No one gets harmed in this. I don't find the testimony that's secondhand hearsay from the city to be relevant. There's been several times in the past, both in these hearings and in other aspects of my dealings with the city, that they don't have the information that you would think that they would. Sometimes that's helped the tenant, and sometimes that hasn't helped the tenant. But I haven't found that the city's records are the end all be all. This to me, I don't know what it's referring to, exceptions in section 6407G and disclosures requiring this disclosure, and 6413 limiting the permissible reasons for terminating or refusing to renew a tenancy. I don't understand what those are referring to, but again, that's why I'm saying refer it back to the hearing examiner, who can do an evidentiary hearing to decide whether this is a valid form or not. And then the two parties can argue, make their case in front of the hearing examiner.
Thank you, Commissioner. Commissioner
Chair
Marshall, please.
Topchin, do you mind if I just wanted to clarify one thing, and I just wanted to make sure I didn't misunderstand Commissioner Kirby's. Sure. In terms of the standard of review here, because we're looking at what the hearing examiner's legal conclusions are, we're looking at it from an appellate standard. So it's like an independent review. It's also called a de novo review. But in terms of de novo, it's not a de novo hearing in the sense where a commission, you could essentially act as the hearing examiner, but the review of the hearing examiner's decision is independent and de novo, and that you can independently look at the law and determine whether or not that law was properly applied. But I just wanted to clarify that in terms of a hearing, this is not a de novo hearing. And if that was not what you meant, then I apologize, Commissioner Kirby's, but I did just want to clarify that.
No, you're addressing what I was saying. So thank you.
Thank you, sir. Thank you for clarification. Commissioner Marshall.
Well, unfortunately, the owner did not ask for a continuance, because that we might have been able to look at this much differently. But since that is not the case, when a landlord fails to re-register a unit following a vacancy as required, he is ineligible to apply any annual general adjustment while a unit remains out of compliance with the registration requirement. So I think here I strongly agree with the hearing examiner's decision, and I will support that. Thank you.
Thank you, Commissioner. Vice Chair O'Keefe.
I would also uphold the hearing examiner's decision, and I agree with the staff report. The continuance was not requested. The landlord did not appear at the hearing to, even if he didn't have the written evidence, to present his case. The issue of the tenant having had the wrong, misremembered the year that he moved in, I don't see as relevant to this. It wasn't essential to the decision. There is substantial evidence on the record to support the decision. There was no re-registration file form in the city's form or in its files. The tenant presented evidence of past payments that are consistent with the amount of the MAR that was found by the hearing examiner. I don't find that the form, I don't find that there was evidence that's presented to us that couldn't have been found with due diligence. Instead, the procedure should have been to request a continuance for. But were I to have found that, I also don't find it persuasive that this form on page 86 is in fact a re-registration form. It doesn't have the amount of rent. It doesn't say re-registration form. Our city ordinance itself is pretty clear that an actual re-registration form has to be filed, and we've heard from city staff that secondhand that see these forms all the time, that this is not what they were, and it wouldn't make sense for it to be, given that the content doesn't even have the actual rent that was charged, nor does it say re-registration form. So it's regrettable that the landlord didn't make it to the hearing and present his case then, but we are not first pass hearing. We are an appellate body, and we have to uphold decisions when there's substantial evidence to support them for the facts. And I don't find that there's an exception where we can consider new evidence.
Thank you, Vice Chair. I just have, I agree with most of what commissioners have said, but I just want to add a couple of comments that the requirement to re-register the unit upon vacancy is paramount in West Hollywood, in the city of West Hollywood, because that's how the department stabilizes the rent, which is the main purpose and intent of the RSO that was passed into law in 1984. So that's the main requirement for the landlords to follow, is to fill out that re-registration form and to report the upon vacancy, what is the rent will be for the subsequent tenancy. So clearly that was not done here in this case. And whatever this document that we discussed is on page 86, that is based on the city attorney's explanation, it is not the re-registration form that existed at the time in 1997. So if this is not the re-registration form that was required to be filled out, then we cannot even consider this for those reasons. This was not part of the hearing, and that is not the re-registration form. So also I want to mention about the 2014 rental agreement, which is staff explained clearly, and I agree with staff that 2014 rental agreement is irrelevant. First, because it was not presented at the hearing, and as the legal counsel explained, this is not the de novo hearing. So we only have to review whether the examiner's findings were correct and they were not in error. So therefore, we cannot substitute the examiner's decision by whatever we discuss, whatever we decide here. So what I'm saying is that the 2014 rental agreement cannot be considered because it was not presented at the hearing. Even if it was presented at the hearing, that 2014 rental agreement cannot override the RSO and set a rent that will exceed the what the rent will be under the RSO, what the legal rent would be under the RSO. In other words, the tenant cannot sign something, and that document cannot be considered as waiving the rights that are guaranteed under the municipal code, which is the RSO, considering in regards to the establishing of the rent level. So therefore, I agree that the examiner's findings are correct, and I would support the staff's recommendation in this case. So with that, commissioners, anyone would like to make a motion?
I'll make a motion. I will make a motion to adopt Resolution RSC 21-591, which is a resolution of the Rent Stabilization Commission of the City of West Hollywood, affirming the hearing examiner's decision in D-4554.
Thank you, Commissioner. We have a motion. Do we have a second?
I'll second it.
Thank you, Vice Chair. We have a motion with a second, and we're ready for a roll call, Mr. Secretary.
Commissioner Bergstein,
Aye.
Commissioner Charity,
Aye.
Commissioner Copeland,
Aye.
Commissioner Kirby's,
Aye.
Commissioner Maggio,
Aye.
Vice Chair O'Keefe,
Aye.
Chair Topchin.
Aye. Motion passes. Thank you. To the parties of the appeal, if you have any questions regarding tonight's appeal, please contact the Rent Stabilization and Housing staff. The telephone number is 323-848-6450. That's the correct number, right, Mr. Secretary?
That's correct.
Thank you. All right, and now, gentlemen, we will place you back in the waiting room. If you'd like to watch the rest of the meeting, you're welcome to do so. You can also watch it online at www.weho.org/WehoTV. All right. Commissioners, that concludes our appeal portion of tonight's agenda. Do you need a 3-minute recess, or we can continue? All right, so then we'll move on to the next item, which is the unfinished business. Excuse me. Under that item, we have one topic, which is the letter regarding broken elevators. As commissioners recall, staff revised the letter outlining the commission's concerns regarding broken elevators after receiving commissioner comments and recommendations at the last meeting on January 28th. So, Mr. Manager Holub, would you like to proceed?
Thank you, Chair Topchin. Good evening again, Jonathan Holub, Acting Manager, Rent Stabilization and Housing Division. On December 10th, 2020, the Commission and staff from the Rent Stabilization, Housing and Code Compliance Divisions engaged in a robust discussion of the issue of broken elevators, their effect on residents, and steps to ensure compliance and reduce impacts on tenants. Following the discussion, staff indicated they would prepare a letter based on the discussion for the Commission's review and to send any combination the letter to the City Council, Human Services Commission, or Disability Advisory Board. At the last meeting, the staff presented a draft letter for the Commission's consideration. Commissioners provided comments at that time on revisions they would like to integrate into the draft letter, and requested that staff return at this meeting with an updated draft. Staff reviewed the proceedings of both meetings, prepared the draft letter attached to this staff report in your packet, and recommends that the Commission move to have the chair execute the letter on the Commission's behalf for transmission to the City Council with copies to the Human Services Commission and the Disability Advisory Board. I'll just make one note. Staff made sure that it integrated all the Commissioners' comments. There was one, however, that I was concerned about and reached out to the Code Compliance Division Manager. That was a recommendation that Code Compliance staff be authorized to make a determination as to whether or not an elevator should be replaced. I was advised that that's just beyond the scope and the expertise of that division. So I kept it out, and my recommendation would be to adopt the letter without that particular recommendation. But that doesn't stop the Code Compliance Division from engaging in robust enforcement. They can order repairs, and of course the other recommendation, which is to increase fines, perhaps more so under some other objective criteria, is certainly something that can be taken up by the City Council. But that just not deciding whether something should be replaced is just not something that's within the scope of this particular division's expertise. Thank you. I'm available for any questions.
Thank you, Ms. Manager. Commissioners, we can address our questions at this time. If you have any comments or questions to make regarding the letter, Commissioner Kirby?
Yeah, I think that, I've reviewed the letter. I think it incorporates all that I can remember from our discussion. I just had a question about, so where it talks in here that we're engaging in review of provisions and may recommend to council the adoption of any change that we come across. I assume that a lot of that will be internal staff work, but when it comes to the council or to the, it'll come to the commission again if it's decided that we need to make some formal recommendations, right? Is that kind of how you see the process?
Are you talking about the proposed integration of some of these suggestions into the temporary relocation ordinance?
I think it was just, it is in that paragraph. Yeah. Yeah.
Yeah. Anything that, for the most part, just in general, if there's an amendment to the RSO being proposed by staff, which at our next meeting that we'll be holding on the 11th, it would come, just like that, it would come to the commission.
Yeah.
First.
My real question is, so when we have that meeting, whenever the meeting occurs, that we might discuss whatever recommendations on elevators, is there a way that we could, I think it'd be easy to invite all of the, or send a letter to all of the owners of these buildings that we know have elevators, but even to the tenants as well. Do you have that ability to let them know about the meeting so that if they want give us input to whatever recommendations we're making, that they would have that opportunity?
To all buildings with elevators?
To the owners of the elevator, to owners of buildings with elevators, or at least whatever standard we wanted to use. The larger buildings, the five stories plus, whatever. I just want to make sure that we're not working in a bubble. We're including not only the people who are affected by it, but the people who have owned the building for 20 years and can tell us what issues they face every day with fixing elevators and things like that.
I don't know if I can do that. I don't know if I have that information. We're looking to see if, which buildings have elevators. I don't know if I could bring the item as quickly as I'd like to, if that were something that we did.
Thank you. Other commissioners? Any comments? Commissioner Maggio?
I just wanted to add that I'm living in a 6-story building where one elevator now has been out for 2 weeks. And it can't be repaired quickly, even though the elevator is only 4 years old. And that's because the part has to be sent to Germany. Unfortunately, some of the seniors are having some problems. And in order to take any elevator, they have to go up one flight of stairs to walk almost, the building's a block long, to walk a block to take that workable elevator down to the floor. However, those who are handicapped are trapped. So there's unfortunately no resolution here other than to wait for the part and for
Commissioner Maggio, I would ask you, with all due respect, if we can focus on the letter, and during your comments, you may continue with whatever you have.
That's all I have to say.
All right, thank you, sir. Vice Chair, I think I saw your hand. No, okay.
I just
all right.
wanted to thank Acting Manager Halib for his work on the letter and say that it reflects, the only comment I had was what he addressed at the beginning, is hoping that we could also order the replacement of elevators, but I understand that code compliance doesn't feel like they have the ability to make that determination. So thank you. I would be happy if we approved it and sent it on. Oh, one thing I would like to also see if we could add a CC for the Historical Preservation Commission, because we do reference that, and I think it is worth keeping them in the loop.
I agree. Thank you, Vice Chair. And I don't really have anything else to add. I was pleased to see that there was a couple of comments that I made at the last meeting, or recommendations, I would say, they're included in the letter, and I appreciate that. And with that, so what would be the action required, Mr. Holub? Do we need a formal vote?
Yeah, recommend a motion to adopt staff's recommendation with the amendment that the Historic Preservation Commission be CC'd as well.
All right. With that, any commissioners, anyone would like to make a motion?
I'll make a motion.
Okay. Commissioner Copeland made a motion to adopt this letter with the suggested amendment made by Vice Chair O'Keefe to copy the Historic Preservation Commission. And with that, do we have a second?
I'll second.
Thank you, Vice Chair. Now we are ready for the roll call.
Commissioner Bergstein?
Aye.
Commissioner Charity?
Aye.
Commissioner Copeland?
Aye.
Commissioner Kirby's?
Aye.
Commissioner Maggio?
Aye.
Vice Chair O'Keefe?
Aye.
Chair Topchin?
Aye. Thank you, and thank you, Mr. Holub, for your work, for this wonderful letter. I think this is what we really wanted to have, and I want to thank Vice Chair O'Keefe for initiating this discussion at the beginning. I appreciate that. With that, that concludes the item 10, unfinished business of tonight's agenda. And let me ask Mr. Secretary, we have any public comments at this time?
Not at this time.
Not at this time. All right. So with that, moving on to the commissioner's comments. Commissioner Bergstein.
Yes, well, with the cancellation of our second meeting in February, more than likely this will be my final meeting as a member of this commission. My partner Raul and I have decided to follow in the path of our ancient peoples and sojourn to the desert, meaning we are going to be moving to Palm Springs, or as I like to call it with a number of City Hall employees retired out there, really it's West Hollywood City Hall East. You know, I came to West Hollywood on vacation in 1988 and then moved here in 1989 to be a part of what was then billed as the gay Camelot. I moved here from Atlanta where, you know, we used to say the rednecks came in around election time and threw bricks at anybody who they thought might be gay. And I knew that in West Hollywood, I could live openly and proudly as a gay man. And I moved here as a gay sober man because I knew that this community, this city greatly valued people being clean and sober from alcohol and drugs and supported our efforts to maintain that. And I moved here as a gay sober man living with HIV. Back in those days, there was nothing to be done. But I knew that this city would protect me from discrimination, protect me from harassment, and if I had any needs, the city would be there for me. I have been extraordinarily fortunate to still be alive and have very few needs that the city assisted me with, but I was grateful for that. A word to landlords, you know, we have always had a voice at this commission, but it has been my honor to be a landlord serving on this commission. But while I may be stepping off this commission, landlords still have that voice. I would always encourage you with any issues to please feel free to reach out to staff. And I would be remiss if I didn't acknowledge and thank a number of people who were very instrumental in my service with the city. First and foremost, former council deputy and member of this commission, Howard Jacobs, who we lost far too soon. We used to have our monthly luncheons where we talked West Hollywood boy stuff, and then we talked service. And he really encouraged me to step up my level of service. And he was the first person I called when I was appointed to this commission. I want to also acknowledge former council deputy Fran Solomon, former manager of this department, Lee Windeman, and Tom West, city clerk. I want to thank our staff for assisting us so well over all these years, and especially Roger, I have to give you another shout out. You know, during my term as chair is when we went with virtual meetings, and it was a lot of kerfluffle going back and forth, but really I would have a question and basically you would answer my question halfway through it. You really helped us be able to move into the virtual world, and I appreciate your work as well as the rest of the staff's work. I want to thank my fellow commissioners, both current and past, for your thoughtful deliberations and your commitment to protecting the rights of both our tenants and landlords. It has been an honor to serve with you.
Thank you, Commissioner Bergstein. Let me go in the alphabetical order. Commissioner Charity.
It's been a pleasure serving with you, Commissioner. You know, I was sitting next to you most of my time here, and it's been very nice to get to know you professionally and personally. And I'll miss seeing you around the neighborhood, and enjoy the sunny, warm weather.
Thank you. Commissioner Copeland.
Well, it's a big surprise to say the least, but I've run into you and not only on this commission, but in the neighborhood, and also doing your volunteer work at the sheriff's station. And we've had some nice conversations there, and there's no denying that your years of service have meant so much and been such appreciated. But I wish you the very, very best in your new venture and in your new home. And I hope you'll be very happy there, but you will definitely be missed here in West Hollywood.
Thank you, Commissioner. Commissioner Kerpes. I'm sorry, yeah, Commissioner Kerpes.
I don't really know what to say other than, Rob, you know that you're a good friend of mine, and we'll really miss you on this commission. It'll be a great loss, but I'm so excited that you're being able to do this because I know this is what you want to do, and I can't wait to come visit.
Thank you. Commissioner Maggio.
Rob, I'm surprised. I didn't know you were leaving. Thank you for your service. I will miss you. I will also miss all the wonderful spinach I get out of your garden every year. And I don't know how I'm going to figure that one out unless you give me the key to the gate. But thank you again, and I wish you well in your new endeavors, to you and to your husband. God bless you. Sei gesund.
Thank you. Vice Chair.
Miss you so much, Commissioner Bergstein. It's always a pleasure to hear so much knowledge and love for the community that you bring when you would say adjournment motions, and very, very thoughtful speaker. Can't believe that you're leaving our city too, and the commission. I'll really miss having you around, and I hope that you love Palm Springs, that you and Raul do. Thank you for all you do.
Rob, you surprised everyone. And listen, this is a really tough moment when, when there's so much I want to say about you. You're an incredible person, and you're a wonderful, I would say, public servant. You've been involved with the city for so many years at any different levels, in different capacities, and the level of incredible level of integrity that you had always demonstrated that high professionalism and care for the community, for the people that you served. And this is incredible. As the first and only landlord in this commission, you've always been impartial, and that is very important. You always stood for the RSO and what the RSO required in your votes, and I truly appreciate that experience working with you. And I was really honored and privileged to work with you as you were the chairperson, as I was the vice chair. You ran excellent meetings. I think you were the best chair we had for a long time. And you've been an excellent commissioner on this commission, and I appreciate your service, your input, and your knowledge and your experience that you brought into the discussion of the items. And above all of that, as I said, you are a wonderful person, a great guy, and it's going to be really sad to see you moving to Palm Springs, although it's a wonderful place to be, but we'll hate to, lose you for you to go. But hopefully you will stay in contact with us, and I wish you well, and wish you good luck. And you will be definitely missed, Commissioner Bergstein. Thank you.
Thank you all, and you're all welcome to come poolside as soon as we're settled in.
We will. We'll definitely will. All right, thank you, commissioners. Moving on to the next, which is staff comments. Manager Hollup, anything from staff?
Well, I wasn't intending on saying anything, but I got a little surprised as well. And I just wanted to thank Commissioner Bergstein for his extraordinary service on this commission. You were here when I got here, and you've done so much for the city and the commission, and you will be missed. But congratulations on your move to Palm Springs, and you can say hi to half my retired colleagues out there for me. Thank you again for your service.
Thank you.
I do have a question for staff.
Yes, of course.
I'm not getting off that easy. This is an issue that we had discussed previously, and not to directly reference the appeal tonight, but there have been other instances where, longtime tenants, it comes to light where the landlord or a prior landlord or a prior owner had never re-registered the unit. And when the city spent a number of years kind of updating and modernizing the computer system for the rent stabilization department, we had talked about perhaps the city running a report and then sending a letter to landlords going, hey, Mr. Landlord, at 1200 Crescent Heights Boulevard, apartment 1 was re-registered here, but just when each apartment was re-registered, to kind of give them a heads up that if there's someone else living there, you may have not registered that document. If you find a copy of it, bring it in. If not, it might be time to rectify it. And the second part of that was, and at the time, the determination was, and if we could take a second look at that, that we had asked if we could offer like an amnesty period. If we notified property owners that certain units had not been re-registered, saying, you have 3 months to register it. And at that point, they said the state law would not allow for that. I don't know if there's a second look on that, but I would ask perhaps if you look at that, and the future commission may discuss that at some point, because it does happen where particularly new property owners did not do their due diligence at close of escrow and did not realize, longtime tenants had not been registered. If we could help educate our landlords, always a good thing. Thank you.
Thank you, Commissioner. And Mr. Hall, before you go, I actually wanted to mention that during my comments, but I was so surprised by the news. Now I want to ask you that question, if it would be possible, and I will explain the reason why. In the appeal discussion, in the finding of facts, when we state that the rent adjustments were not lawfully implemented, which we agreed that were unlawful rent increases, but and the question that I asked regarding the notification, I asked the legal counsel about that. In my opinion, what makes the rent unlawful is what I see on the surface, like three components that would make the rent unlawful. Number one is the failure to re-register the unit upon vacancy. Number two, if the percentage applied would exceed the permissible RSO percentage. And the third, I think it's also important, whether written notification was provided or not. So I wonder if we could, I wouldn't say require, but maybe I don't know, maybe we can suggest or advise that the examiners during the rent increase, review of rent increase applications would ask these questions, would look into the written notification issue, whether the notice was issued or not. Because if the notice was not issued and the increases were imposed verbally, so the fact that the tenant overpaid, it can be established. But if the written notification process was not followed, so then the rent increase, the rent cannot be actually adjusted after, let's say, the owner fills out the re-registration form. So that rent increase will be invalid and should not, the annual adjustment should not be allowed if no written notification is given. That's how I see it. And maybe, I mean, I don't expect you to answer now if you don't have the answer, or maybe at the later time in another meeting, you can bring this up and explain.
Sure. I mean, I have some thoughts on it, but I think it would be better perhaps if I addressed it at a later date.
Okay, thank you. Thank you very much. All right, that's it, I think, for tonight. And this concludes our tonight's meeting. Commissioners, the February 25th regular meeting will be canceled as was announced. So the next regular meeting of the Rent Stabilization Commission will be held at 7 p.m. on March 11th, 2021 via Zoom conference, when we will be discussing proposed changes to the temporary relocation ordinance. Thank you, everyone. Good night. Stay safe.
Good night, everyone.
Take care. Take care.
Bye-bye.